And hello, everyone. Thanks for coming to this last of these online sessions. What we're going to be doing today to start with is we're going to be going through the contract that I asked you to take a look at. Hopefully you will never in your lives see again a contract that's that badly written. And I'm just going to ask people in order just to, and to please do this over the phone, not through chat, otherwise it'll take too long. Unmute your lines and tell us something that you found, and it can be anything. And remember, there's going to be a valuable prize for the person who makes the most substantive comment, and also a prize for the person who finds the nitpickiest nitpick. Oh, I'm sorry. I forgot to, well, here I am. I forgot to press the button to make this start, and thank you for reminding me, Jessica. And what we're going to do now is we're just going to go directly to the contract. We'll be looking at the contract together on the screen. Excuse me. And if you, if you want to, when I call your name, you can pass. That's fine. But if you've got something to, any comments on the document, please share them with the group. So I'm just getting the contract loaded here, and that should. And what I'm going to do, just because I know people at the beginning of the alphabet and at the end of the alphabet, and our list is alphabetized by first name, but I'm going to start in the middle of the list here. I'm going to start with Dan. Start off with Dan. Oh, I have the wrong document open. Hold on. Sorry about that. Start with Dan, and if Dan could just point out something that he found in this document, be it large or small, just to get the ball rolling here.
All right, I'll start at the beginning. In the preamble, the entity for Toys R Us Corp is listed, but not the entity for Tons of Fun.
Yeah. This contract says Toys R Us Corp. and Idaho Corporation, but doesn't do the same thing for Tons of Fun. There's no requirement that you identify the entity by what kind of entity it is and what state it's organized under, but if you do that for one, you need to do that for both. So that's a good catch, Dan. Greg, do you have something?
Yes. In section 1C, it says it shall be responsible for all costs of delivery, and it is ambiguous.
It is ambiguous there. So that's a substantive point. So, Jessica, we're going to put Greg down as in the running for the substance award, because that's an ambiguity. That could give rise to a dispute. So we'll put Greg down for, just put him down for it. That way I'll remember what it was. Kevin.
Hi, so in section 1A, it says the parties hereby agree, which is kind of redundant since the sentence before says the parties agree as follows.
That is correct. This is actually one of my biggest pet peeves. Is in a contract, by definition, the parties are agreeing to everything. That's what a contract is. And so why would we ever start a sentence or a paragraph or a section by saying the parties agree to this sentence or this paragraph? They're agreeing to the whole thing. So it's redundant and unnecessary, and I would always advocate taking it out. Now, having said that, you guys, as junior lawyers, if you start rewriting the form, people are going to be unhappy. So if this is how the form reads, I wouldn't advocate changing it. But, don't you ever write a provision like this. You're up to Lori.
May I pass, please?
You may.
Thank you.
And that brings us to Margaret.
I I'm late, so I haven't gotten to follow the activity.
Okay. We'll come around again because everybody's going to get hit, more than once except for people who pass. So the next person is Michael Mitchell.
Yeah, how you doing?
Good.
Up top there, equipment, I just thought it was a little late in the sentence. Shouldn't it come after the word equipment there? Or if it's going to try and define what equipment is?
Where the definition is kind of late. I think it's always better to put the, a definition like this closer to the actual subject that it modifies, which would be, right in here. So yeah, I would definitely do that. Will.
Yes, one thing I thought was a little out there was that equipment is not defined anywhere by an addendum or a schedule or anything like that.
Yeah, look at how equipment is defined here. Here's the definition of equipment, and it just says seller owns certain equipment that it proposes to sell to buyer. Then it defines that as equipment. What equipment? Let's put Will down for the substance prize because that's very substantive, right? This contract doesn't even correctly identify the subject matter of the contract. And for that reason, I think there's a pretty good argument that this contract is not even enforceable. And as Will points out, if in many cases, the way to do this would be to attach a schedule. So it would say seller owns the equipment listed on Schedule A that it proposes to sell to buyer. And you do that if there was a list of equipment. I mean, if you were selling one piece of equipment, you probably wouldn't need a schedule. But if it's a bunch of equipment, rather than list it all here in the recitals, which would be unwieldy, we just would schedule it. But certainly, we need to define it better than it's defined here. Okay, that brings us up to the top of the list. And Allison.
Can you hear me?
Yes, I can.
Okay, sorry, I was on mute. Closing date is used as a defined term in 1A,
yep.
But it's not defined yet.
Okay, so closing date is used as a defined term. It's not defined yet, but it is defined here in the definition section at the end. So you might think a way to handle that is to say back at the beginning where it's first used, closing date as hereinafter defined. I'm not a big fan of that because in if all of the terms that are defined in the text, then every term should be defined the first time that it's used. In agreements that do have a definition section, like this one does, when a term is capitalized but not defined, so, for example, purchase price happens to be defined here, but other terms are defined in the definition section, the reader should just know to look for the definition section and see if that's defined. Andrew.
Hi.
Hi.
So I guess the thing I saw was if you look in the definition section, it says purchase price has meaning set forth in section 2.1, but if you look at section 2, there's nothing about the purchase price, and there's actually not even technically 2.1, it's 2A, BC.
Yeah. There's no section 2.1, and even if there were, nothing in section 2 refers to the purchase price. In fact, purchase price is defined here in 1A. So that's a good catch. When you're reviewing a contract, you should be checking all the cross-references like that and seeing if they make sense. Ashley.
Ashley, you're on mute. There you go.
Hear me?
Yep, hear you now.
Okay, sorry about that. I'm having trouble hearing, so I hope I don't do one that someone already's done. But,
okay.
Under A1, buyer shall have an opportunity to inspect the equipment and shall have concluded that it is in satisfactory condition. There's no mechanism to determine what is satisfactory condition. Is it objective is it subjective? We're just not sure.
Yes. That's a good catch. Nobody's mentioned that before. One of the instructions you had was to make sure there wasn't anything that was terribly one-sided in this agreement, and this is an extremely one-sided provision. It gives the buyer pretty much a blank check to say, we're not satisfied, and to then walk away from the deal because the condition, hasn't been satisfied. So it's a very unreasonable provision from that standpoint, and that's very substantive. I think no seller, if they're paying attention, is ever going to agree to this. If I was the seller, what I would probably want in an ideal world is I'd want the buyer to inspect the equipment before the contract is signed. I'd want a statement from the buyer that they're satisfied with the condition in that inspection, and then this condition, I'd want to say that, buyer has, reasonably concluded that the equipment is, in at least as good condition as it was when they did their pre-signing inspection. And that would really tie the buyer's hands. The way this is written, the buyer has carte blanche. So let's put, let's put Ashley down in the substance column, Jessica, for the satisfactory condition comment. And that brings us to Cody.
I found that the signature blocks don't match up, so I made Toys Were Us Corp all caps to match Tons of Fun.
Yes. The convention, and this is not anything that's legally required, but the convention for signature blocks is that we put the names of entities in all caps. And so that should be done here as well. Thank you, Cody. That brings us to Dan. Back to Dan.
The fonts in 2A doesn't seem to match the rest of the agreement.
2A, yeah, 2A, this thing here. And it doesn't. It's close, but it's not the same. And Dan, do you have any thoughts as to how something like that would happen?
They probably copy and pasted it.
That's correct. When you copy and paste, which you're going to be doing because you're all professional plagiarists now, you really need to both make sure that the format and style of the language you're inserting matches the document that you're inserting it into, but also check the substance to make sure that substantively it meshes properly. Here, it's just the font is a problem. Greg.
Yes, can I pass?
Yes, you can.
Thanks.
And that brings us to Kevin. Kevin, are you there? Well, we'll come back to Kevin. Lori had passed already, so that brings us to Margaret.
I haven't had a chance to go over this yet. I'm sorry.
Oh, okay, that's no problem. And that brings us to Michael.
Hey, how are you? So I was looking at the now and therefore, and
yep.
I didn't think that there was a comma in between now and therefore. I thought it was just a comma after therefore.
Now, therefore, now, comma, therefore. I think you're right. Now, therefore. And just so you guys know, this preamble here, it sounds very old-fashioned, and it is. People who are advocates of a more modern style of contract drafting don't use the whereas and now therefore. They just call this background, and number these paragraphs. I mean, the recitals, these are the recitals, and they're there. They're not required. They're there to give the reader some background on what's going on in the contract. So they're very helpful to a reader, but the language is certainly somewhat archaic. But that's not to say you're not going to see this probably more frequently than you see the more modern approach. Will?
There's down in section 2.1, in subparagraphs A, B, and C, after the little subtitles there, enforceability, environmental liabilities, and manufacturer's warranties, there's different numbers of spaces.
Yes.
Look at this. That's it up to be just 2 spaces.
Yeah, that's a very nitpicky nitpick there, Will. So we're going to put Will on the nitpick list for the inconsistent spacing. And, you know, this is the kind of little thing that is easy to miss unless you're a lawyer who's done this for a long time, in which case most of us are going to catch it every time because we have become that kind of person, and you will become that kind of person soon enough. But that's a good catch. So that brings us, let's see, that brings us back. We'll do one more, maybe one more go around, or maybe 2. That brings us to back to Allison. And by the way, I'm trying to keep track of who passed and who didn't, but if you passed and I'm calling on you, just say pass again, and I apologize for. Now I see that there's no phone icon next to Allison's name, so that suggests to me that she's not hooked up by phone. So that means I'm going to go to Andrew.
She might have just disconnected on accident, so maybe.
Yeah. Okay. So let's go with Andrew.
Sure. Can you go back up to the whereas section?
Sure.
I know mine was looking like the 2 whereas, one of them was in small caps and one of them was in all caps, but I might be just looking at that weird.
Yeah, they are the same size.
Oh, they're spelled different though.
Yeah.
Spelled different. Yeah, I knew something looked weird about this.
That was this whereas that I've highlighted here is spelled wrong, and how can it be that spell check would miss that? The answer is, I believe that if things are in all caps, spell check doesn't work, or it certainly doesn't work in my on my system. So it's just another example of how spell check only goes so far. Ashley, do you have something to share with us?
Hi. In the very first, actually in the second line, the buyer should be within the comma, so before the comma, because it's clarifying. Tons of fun.
Yes, well, the comma before the open parentheses is a mistake. You never have a comma before the open parentheses. But then the question is, do we need a comma here at all? And the answer is, well, we do now, because if you remember, the first comment was we're going to add, a Delaware corporation here, so then we would need a comma, but the comma would go after the parenthetical. So, Jessica, let's put Ashley down for the misplaced comma. We've got a lot of people vying for the nitpick award here. Cody.
On 2B, I changed the title from environmental liabilities to just title. It felt like it's more representative of the clause.
Yeah. 2B, the heading is environmental liabilities, but the provision itself has nothing to do with environmental liabilities. So we've got to change the heading to title, which is the right thing to call it. Headings are not considered a substantive part of the contract. And therefore, this mistake is not going to affect the interpretation of the contract, but it's an example of a mistake that could be misleading to people. You know, if they're just flipping through the contract and looking for a rep on title, they're likely to skip over this, which, by the way, is something you shouldn't do. You should never just rely on the headings. You should actually read the provision just to be sure that there isn't a mistake like this. But in the context of making a contract user-friendly, we do need to try to make sure that the headings create a meaningful roadmap to the readers. Dan.
In 2A, they act like they're starting a list with that A in the middle of the paragraph and don't have anything after it.
That's correct. Why would you have an A there if there isn't a B? So
again, I think they copy and pasted.
Well, it could be copying and pasting. Certainly there's something wrong there. Now, I will tell you that this clause, this rep, does usually have a B. And I'm just going to sort of go off on a tangent here a little bit and tell you guys what this rep is all about. This is a rep to the effect that, hey, this contract is enforceable, meaning this contract works as a contract. But there are two customary exceptions to that statement. The first one being the one that you see here, which is, you know, subject to the effect of bankruptcy laws. And the reason we have that exception is because when a company files for bankruptcy or a person files for bankruptcy, because of the automatic stay that is imposed by the bankruptcy law, their contracts are specifically not enforceable in accordance with their terms. Counterparties to contracts are blocked by the automatic stay from enforcing those contracts. They have to, you know, they can't enforce the contracts by the contract's terms. Instead, their sole right is to assert their claim in the bankruptcy proceedings. So that's why we have this first exception. The second exception, which is not here but should be here, is an exception for what we call equitable principles. And what that's getting to is that when you sue under a contract, you can either sue at law or sue in equity. And if you're suing at law, what that means is you're looking for money damages. If you're suing in equity, it means you're looking for an equitable remedy, which in the case of a contract would most likely be specific performance. That is, asking a judge to order, not money damages, but to order one of the parties to the contract to do something. And judges don't have to provide that kind of remedy. It's up to the judge. They have a lot of discretion in order to give those kinds of equitable remedies. And that's why, you know, there's an exception usually here, which I deleted, for, you know, we're not giving you a rep that it's enforceable in accordance with equitable principles because that's really up to the judge. Now, assuming that clause was in here, you wouldn't want to have these two exceptions listed as A and B because the clause there within is an A clause. You want to, when you're enumerating, you want to switch back and forth. But so it probably, I would probably put in a one little I and two little I's there, you know, in order to have that kind of alternation. Okay, that brings us to Drew. I think Drew, I don't think I've called on you yet. So Drew, if you have something, please share it with us. And if you need to pass, of course, you're free to do that.
So I just show up late to this. I apologize. So I'm not sure what you all have covered and what not. So I'm going to pass on this one.
Okay, fair enough. And then then I know we've got a bunch of people who asked to pass. So that brings us. We'll go around one more time. So Michael, you have one more thing for us.
Yeah, I can give it a shot. Section 1B.
Yeah.
I thought commencing on the closing day was a little bit ambiguous. I don't know, like if it, you know, at what point, maybe after the transaction closes, is when the liability should, the risk of loss should start. I also thought, and on
Go
every
ahead.
calendar day thereafter was maybe a little excess verbiage.
That's definitely excess verbiage. If you say commencing on the closing date, that without anything else, that tells us, that means from that point forward. So the end on every calendar day thereafter, that's definitely excess verbiage. And commencing it on the closing date, I agree that's a little bit imprecise because if the closing occurs at 3 in the afternoon, should the buyer be subject to risk of loss on the equipment, at 9 in the morning? No, it should commence at the time of closing. So I think that's a good catch. Okay, we are up to Will.
This is kind of along the lines of the closing date discussion.
Yeah.
Actually, I think that, so in paragraph 1B, which mentions commencing on the closing date for bearing the risk of loss, and also in paragraph 4A, which talks about the maintenance or maintaining the equipment in good condition, both of those referencing the closing date would make me feel uncomfortable. I'd rather they both reference simply the date of delivery, which could theoretically be different from the closing date, and then further define date of delivery as when the seller has delivered the goods to the buyer.
That's absolutely true. I mean, one of the problems with this contract is this clause, 1C, seller shall deliver the equipment to buyer. It doesn't say when. If it happens at the time of closing, which by the way is unlikely because, it's not, this isn't something that's going to necessarily you can time that accurately. So if it happens after closing, I agree with you absolutely, Will, that you would not want either B here, 1B, which talks about risk of loss, and paragraph 4A, which talks about maintaining the equipment in good condition. You would want both of those tied to the date of delivery, not the date of closing if they're different. Okay, Andrew, we're going to go around one more time. Wait a second, Allison, I missed you. Okay, Allison wasn't on the phone before, but there she is. So Allison, do you have something for us?
Yeah, I'm sorry. I didn't realize I hung up instead of unmuting the phone before.
No problem. I do things like that all the
Because
time.
of that, I sort of lost track of which edits we went over.
Yeah.
So I think I'm going to have to pass.
Okay. Andrew.
This is Drew. I can pop in here if you want me to.
I'm looking for, okay, Andrew Erickson doesn't have a phone, so I think that brings us up to Ashley.
Hello. So in in section 3B,
3B.
conditions to the seller's performance.
Yes.
I'm not 100%, but I think under 2, it needs to be that the representations and warranties are true and correct as of the date of closing.
Correct. This should be a bring down of the reps. And the way it's written, it's not a bring down. It just says the reps and warranties have to be true as of the date of this agreement. And notice that the above the conditions to buyer's performance, it says seller's reps have to be true and correct as of the closing date. In fact, both of them should say the other party's reps and warranties should be true and correct as of the closing date and the date of this agreement. So that's a good catch. Okay, we are now up to Cody.
I'm going to have to pass.
Okay. Well, you know what? Since we have so many passes now, I think we'll just wrap this up. I think you guys got a lot of the errors that were in here. I'm just trying to think if there's any others that are so egregious that I want to point them out to you. I think you guys got most of the big ones, so I'm just scrolling through here to see if there's anything else that's kind of worth mentioning. And I don't think so. I think you guys got the biggest ones. So with that, I'm going to get rid of this document, and we're going to go back to the that screen. Thank you, Jessica. And let's see. Jessica, I'm just looking for the list of, I want to announce the winners here. So if you would show us the list of okay, you know what? While Jessica's filling that in, I'll just start talking about something else. We'll come back to that. And before we get to anything, here's another one of these, which is the third. You know, there's 3 prizes that are going to be given out at the end of this, and this is the thing we've been doing the last couple of times, which is looking for the excess verbiage. So all you need is to type the word cut into the chat box. Ashley, what do you have? Significant, correct. The word significant here is redundant with the word material. Significant and material have basically the same meaning. So why would you say both of them? That's probably just a mistake. Probably in the first draft, it was just referred to a significant effect on lessee's business or financial condition. And then after that, people said, well, let's use a material adverse effect standard. And then, you know, the word significant wasn't deleted. So, Jessica, make sure that Ashley gets on the list for the anti-win-back award. And what I want to spend the rest of our time this afternoon talking about is contracts and due diligence. And the due diligence that first years do is primarily due diligence on 2 basic kinds of things. The first category being corporate documents, things like articles of incorporation, bylaws, board minutes, etc. The second major category being contracts. What happens, unfortunately, is that when you're given a due diligence assignment, and I don't know if this has happened to any of you yet, but sometimes the senior lawyer who's giving you the assignment is not as clear as they could be, telling you what it is that you should be looking for. They might say, they might say things like, oh, you know, just look for things that are out of the ordinary, or look for things that raise red flags, and obviously that's not very helpful to you. So we don't have time today for me to talk about all the kinds of red flags that you'd be looking for in contracts, but I'm going to focus on one particular kind of red flag, which is an issue, potential issue in every deal. So when you're doing due diligence on contracts, this issue that I'm about to describe is something that you should always be on the lookout for. And it's the subject in many, many, many contracts of a representation. And this is a representation that relates to this issue. The company's execution, delivery, and performance of this agreement do not violate or create a breach of any other agreement to which the company is a party. And what you're on the lookout for when you're reviewing contracts is anything in an existing contract of a company that's entering into a new transaction that would make this representation untrue. So to clarify what I mean by that, I've got some diagrams. This is the scenario that we're looking for. Party A and Party B entered into a contract, say a year ago, in which Party A has agreed not to do something, which I'm calling X here. It could be anything. It's a covenant not to do something. That contract is still in force and effect. It's out there, and Party A has this covenant under it. Now Party A is negotiating a new contract, which is totally unrelated to the contract it has with Party B, in which Party C wants Party A to agree to do X. So Party C wants Party A to agree to do something that it's prohibited from doing in one of its existing contracts. This is this kind of situation that we're on the lookout for. So when you're reviewing the Party A's existing contracts and you find in the contract that Party A has with Party B that Party A has agreed not to do X, and you know that in the new transaction that Party A is proposing to do, it's going to be required to do X, or it wants to be able to do X, you have a problem. And we call this a conflict. Not a conflict of interest, but a conflict between contracts. And, you know, if you find a provision in an existing contract of a party to a transaction you're working on that restricts the party's ability to do something that it's proposing to do in the new transaction, or prohibits it, or the existing contract terminates, if the party you're looking at enters into or performs its obligations under the new transaction you're working on, if you see any of those things in the existing contracts of Party A, this is something that people are going to want to know about. And in almost all cases, people are not going to want to let Party A enter into this contract with Party C, in which Party A agrees to do something that it currently has a contractual obligation not to do. So what people will do is they'll either go, say, let's go to Party B and get a consent from them that basically says it's okay if Party A agrees, and does X, agrees with Party C to do X and does it. So basically Party B is consenting to it, notwithstanding the fact that they have a contractual right to block it. That could also be done under a document called a waiver, either a waiver or a consent. So we'll either get Party B to bless it, or we'll get Party C, we'll convince Party C not to require that covenant from Party A. And almost everybody is going to want to achieve one of those two objectives because of all of the potential bad things that flow from letting Party A and Party C enter into this agreement with this troublesome covenant in there. And let's take a look at what those negative impacts are. Oh, and by the way, what could X be? X could be anything. But here's a list of the kinds of things that most often create problems. So let's look at the first one, incurrence of debt. And going back to the previous slide, if Party A has a contract with Party B where it has said, we will not incur debt, or we will not incur debt in excess of X million dollars, and now Party A is proposing to enter into the transaction with Party C where it's incurring debt, borrowing money from Party C, obviously that's an issue. So this list of things that X could be, this is not an exhaustive list, but this is a list of some of the things that are most often the subject of these kinds of conflicts. And just again, to go back to the previous slide, in order for you guys to do this due diligence and your other due diligence properly, you really need to understand pretty well what Party A is doing or proposes to do under this deal that it's negotiating with Party C. If you're kept in the dark about what's going on between Party A and Party C, you're not going to be equipped to identify potential conflicts. So this is one reason why you need to get as good an understanding as you can of what is going on in this deal that you're doing due diligence on. What obligations are Party A assuming? You know, what is it required to do? What are the basic outlines of the deal, et cetera? So if you're not given that information before you do a due diligence assignment, you really should ask and push and ask whoever you can ask to find out as much as you can about the deal that's going on, because the more you know about the deal, the more likely it's going to be that you'll be able to find this issue and also identify other issues as you review the contracts and the other documents you're going to be looking at. Okay, so let's look at some of the adverse consequences if we let Party A and Party C sign this contract that has this offensive clause in it. First problem is that if we do, Party B will have a claim for tortious interference against Party C. The claim is basically, hey, Party C, you are contractually requiring Party A to breach its contract with us, right? If Party A complies with your contract, by definition, they're breaching our contract. So you're inducing them to breach our contract. And there was actually a really interesting example of this kind of claim in the news a couple of years ago. It involved Martha Stewart, Macy's, and J.C. Penney. And what happened was Party A was Martha Stewart, the Martha Stewart Company. Party B was Macy's, and they had an existing contract in which Macy's had the right to sell Martha Stewart homewares, and it was an exclusive right, but there was an exception to the exclusiveness paragraph that said Martha Stewart could sell homewares in a Martha Stewart store. But other than that, Macy's was given the exclusive right to do these sales. Party C in this case was J.C. Penney, and Party C got in touch with, J.C. Penney got in touch with Martha Stewart and said, we'd like to sell your homewares in our store. And Martha Stewart said, well, you know, we have this contract with Macy's. So they put their heads together, they looked at it, and they came up with an idea. And the idea, so they had an idea and they signed a contract and they actually executed this idea. And the idea was that J.C. Penney, on its sales floor, in its stores, would have actually created this little structure. Like I picture it as kind of a little house or something. That they put a sign on that said Martha Stewart Store. And within that structure, they had Martha Stewart homewares, and they were selling them. So as soon as Macy's got wind of this, they sued Martha Stewart for breach of contract, and they sued J.C. Penney's for tortious interference, saying to J.C. Penney, you are inducing Martha Stewart to violate this exclusiveness provision we have. So the case went to court, and the stories in the paper, described some of the testimony and so forth. And what happened was, halfway through the case, they settled because it was very clear pretty quickly that this thing that J.C. Penney and Martha Stewart came up with was never going to fly. It was not going to be interpreted to be a Martha Stewart store in accordance with the provision in the agreement between Martha Stewart and Macy's. Right? It wasn't a Martha Stewart store. It was J.C. Penney's selling inventory they bought from Martha Stewart, and they just put like a name up there, Martha Stewart Store. And this illustrates, first of all, it illustrates this potential issue for tortious interference claims. But it also illustrates an issue that comes up when lawyers, over time, we develop, and appropriately so, a belief that words have great power. But sometimes we get carried away. And in this case, the lawyers got carried away and thought that they could change reality by using words. And usually that doesn't work, right? When you hear lawyers use the word deem, like we're going to deem this payment to be the payment of rent, what they usually mean is we're going to take a cat and call it a dog. And sometimes that's fine, but you always have to remember that when you're doing that, when you're trying to change reality with words, that there's a very good chance that if that is ever examined by, say, the Internal Revenue Service or by perhaps a judge, folks like that are going to look through what you call things and try to look at what they actually are. So here, that's what was clearly going to happen. The judge was going to look straight through this and say, come on, this is not a Martha Stewart store, and just by calling it one doesn't make it one. Okay, so this is problem number one with this type of contract conflict. Problem number two is that there's a very good chance that Party A is going to be in breach of this contract with Party C right at the beginning, from the moment it signs the contract. Now, that's not automatic, but there's a very good chance of it. And why would they be in breach of that contract? They would be in breach of that contract, and I'm going to backtrack here, if Party A has made this representation that I started with. And in the deals that you guys do, you're going to see that this representation is extremely common. Why is it common? Because people care about this issue. And they want to know that there isn't this kind of conflict. So if the Party A has made this representation, once they sign the contract with Party C, that rep is not going to be true at that time, and therefore they will have breached the rep and will be in breach of the contract. So that's the second problem with this type of potential conflict. The third problem is that there is case law and also law under the Restatement of Contracts that the contract between Party A and Party C, or at least the portion of the contract relating to X, is unenforceable, meaning it doesn't work. It can't be enforced as a contract. And the contracts that we work on as deal lawyers, enforceability is our goal. We don't want to create contracts that are either non-enforceable or partially unenforceable. That flies in the face of what we were hired to do. So that's a significant problem. And this is the language in the second Restatement of Contracts that says that. It basically says if a promise gives rise to a tortious interference claim, it's also unenforceable on grounds of public policy. And then before I get to that, the last problem is that as it relates to X, whatever X is, Party A is going to be in default of one of these contracts or the other one by definition, because it can't both do X and not do X. So lots of problems with this kind of conflict, and therefore this is something that is always the subject of due diligence. If you're looking at a party's existing contracts as part of the due diligence on that party doing a new deal, is there anything in its existing contracts that prohibits or limits or prevents it from doing what it's proposing to do under the new contract? We have another one of these. Type cut if you can figure out what needs to be or what can be excised here. this can be said a lot more succinctly. Will, what do you think? Accept the sale of specified securities. I think Will, Will got that right. It should say the company shall not sell any assets except the sale of the specified securities. Or you could even say, it could even be shorter by saying the company shall not sell any assets except the specified securities. You don't even need to say except the sale of the specified securities. So we've basically cut more than half of this sentence. Not that it's a substantive change, but it is a lot easier to read. I want to look at a few examples of potential conflicts, going back to the whole issue of potential conflicts between contracts. Here's a provision. Let's say you're working on a lease, and you represent the landlord, and your client, the landlord, says, I want to make sure that the tenant, the lessee, isn't stiffing me if they're making payments to their other landlords. I don't want to feel like a chump and find out that they're paying their other landlords at a time when they're not paying me. So I want you to put this provision in the lease. This is a provision that would say, hey, if the lessee's not paying my rent, they shouldn't be paying rent to their other landlords. Is this an issue, or is this likely an issue? Obviously, you can't do this conflict analysis without looking at the other contracts. So you would need to look at the other leases to do this analysis completely. But the odds are very high that this is going to create a conflict. Why? Because what this provision is basically saying to the lessee, if you're in default under my contract, you are now required contractually to default under your other contracts. The only way this one would not be a conflict is if all of the other leases said that the lessee doesn't have to pay rent under those leases if they're not paying rent under this one, which is very unlikely. So this is a really pretty clear example of a potential conflict. And of course, this is, if you could put this in there, your client would be very happy. This is what we call, or some people call, schmuck insurance. That is, I don't want to feel like a schmuck and find out that they're paying other people and not paying me. But we would have to tell our client here, sorry, this exposes you to risk and probably isn't enforceable. We're not going to put that in the contract. How about this one? Under an existing mortgage that Company A has, it has the option to pay interest either by paying cash or issuing additional notes. We call this a pay in kind. You don't have to pay cash. You have the option of basically adding to the principal amount you owe under the mortgage. So now it's negotiating a new agreement that contains the following provision. Company A shall make interest payments under that existing mortgage by issuing notes. Is this a conflict between this new provision and the existing mortgage? Does this create a conflict? And the answer is no, it doesn't. Why doesn't it? Because by complying with this provision, Company A is not going to be in violation of its existing mortgage. All this provision does is requires Company A to exercise an option that it has under the existing mortgage. And by doing that, Company A doesn't breach it. So, not a problem. And I'll do one more example. Your client wants to enter into a $100 million revolving credit agreement. It's party to a bond indenture that has this covenant in it. The issuer, that's your client, shall not incur debt except for, and then there's a list of exceptions, none of which would apply, except for this clause F, which permits up to $200 million of debt at any time outstanding. Well, if you're doing this analysis, of course, you're going to look at the defined term debt to see if, in fact, the loans under this proposed $100 million revolving credit agreement will constitute debt, but the odds are very high that it would, and let's assume that it does. So it does. So borrowings under this revolver would be covered by this covenant, but we have a $200 million basket. So that will take us out of the woods here, and your initial reaction could very well be, sure, this gives room of $200 million, and the company's only borrowing up to $100 million. But that isn't correct, because baskets like this, exceptions like this, you can't look at them and think that there's necessarily $200 million of room here, because it could be that the issuer has incurred other debt that is still outstanding in reliance on this basket, in which case the amount of that debt needs to be subtracted from the basket to see how much of the basket is still available. So if you ask the company and say, how much debt do you have currently that relies on this basket, if they say $50 million, then you're okay. If they say $150 million, then there's only $50 million left in the basket, and there's a potential problem. Okay, so that, it's 4 o'clock, so I want to get you guys out of here on time. Again, I'm going to open it up to questions. Anybody who has any questions, please ask them. In terms of the awards, I will tell you now that what I'm going to send out for the people who won, it's a gift certificate to Starbucks, which will, contrary to being very valuable, which is what I've said all along, it will buy you one beverage as long as you don't order the most expensive thing on the menu. In terms of the nitpick and substance award, unfortunately, what I'm going to have to do is go back and take a look at the notes to see who won those. And I will, what I'll do in any event is I'll make sure that the people who won are notified, and then I'm going to send these gift certificates to Gala to distribute them to the relevant folks. So if anybody has any questions, please feel free to ask them in the Q&A box. Oh, by the way, the anti-windbag award, we know that one. That goes to Will. He got a lot of those right, so Will will be getting that. Anybody who has questions, please ask them. Otherwise, everybody's free to go. Thanks for spending the time with me. I hope these sessions have been useful. I hope you've picked some stuff up that you'll be able to use. And if you can think of any way that this can be improved or other things I should be covering, don't hesitate to let me know. But otherwise, I wish you well. I hope you all do well in your careers. Thank you.